My name is Bertrand de la Chapelle. I'm the director of the Internet and Jurisdiction Project. And the title of this session, as you can see, is dealing with preventing a fragmentation of cyberspace and how to develop a cooperation framework to prevent the fragmentation of cyberspace. I'm particularly happy to have all the people who are on the panel here, and I will start from here, for instance. Dirk Brengelmann is from the Ministry of Foreign Affairs of Germany. Eduardo Bertoni is, was the former rapporteur for freedom of expression for the Latin American Organization of American States, and is now in Argentina at CELE. Olof Ehrenkrona is from the Ministry of Foreign Affairs of Sweden. Chris Painter is from the State Department in the US. Joana Varon is from the Fundación Getúlio Vargas in Brazil. Nicolas Sadler is from ISOC. And finally, Andrew Pudupat is from Global Partners. You will see on the table two documents that we're happy to share regarding the Internet and Jurisdiction Project. And I would like to do during this session is to basically paint the landscape of the challenges that are related to the tension between the transborder nature of the Internet and the patchwork of national jurisdictions. In a nutshell, the three elements that we're going to explore is first the result or the consequences of the transborder nature of the Internet in terms of legal challenges. The second element is the current situation of the legal space, which is a fragmentation de facto along national boundaries. And the third element is the need for cooperation. And without further ado, I'd like to weave the discussion by asking Nicolas to elaborate a little bit on one element that I think is a fundamental underlying point, which is that the jurisdictional tensions that we see are actually a result of the success of the Internet rather than a flow. Can you elaborate? And then the other panelists can chime in as they see fit on those threads. There's no 5-minute statements for the start. It's more flow. Nicolas.
Thanks, Bertrand, and good morning. So yeah, I very much agree with your statement. I do think that we need to fix the jurisdictional issues, but yeah, to a large extent, the fact that we have jurisdiction issues and tensions is a good problem because it means that the Internet is a network that does not recognize borders. Vint Cerf, repeated that yesterday at the Big Tent event. The design of the Internet was not made to recognize national borders, and while that brings a set of benefits, it means that people can, share information and ideas across frontiers. It means that people can create innovate, create one service in one part of the world, and it's accessible in, at the other side of the world. So again, I think that we do have a shared technical space that creates tensions with jurisdictions, but I prefer to fix the jurisdictional issues and keep a unified Internet rather than the other way around. And I think that if the tensions and if the legal frictions are not fixed, I would be fearful that governments suddenly decide, okay, well, we cannot fix the legal issues, so we need to have a national Internet, technically, so that we can, more easily apply our national jurisdictions. And I think that would be a bad outcome.
What you highlight is actually, I think everybody agrees on the borderless nature of the infrastructure. It was not conceived as such. But here we're probably talking more about cyberspace. If I go back to the distinction that Vint Cerf was making yesterday about the different layers, the jurisdictional issue is more on the social and application layer than on the infrastructure layer. Eduardo, you wanted to make a comment?
Actually, my comment is to put this problem into a real problem, real cases problem. And in our center, by the way, there is some information about the center in the back. We published 3 years ago some research, and one of the chapters was related to the jurisdictional problem, but we focused the problem on defamation online. Because what we realize, at least in Latin America, but I think there is a global problem, is that the domestic laws on defamation are very different from one country to the other country. So maybe this is not a new problem. Maybe this the same problem that we used to have in the past when, for example, the New York Times published something in the United States and somebody read the article in, let's say, South Africa. But the scale, the power of internet today is very strong. So we envision that this is going to be a real problem if we don't advance to fix this jurisdictional problem. So we did some proposals in some suggestions in our research. And again, we published that in 2011, and one of the suggestions was to try to get some sort of international agreements that at least agree on the jurisdiction, saying, okay, the jurisdiction will be the place where the author has his or her residence, or where the victim is based, or where the server who allocated, the defamation content is allocated. So, I mean, we need to think creatively on how we are going to fix this problem, because we have the cyberspace in one side, but we still have domestic laws on the other side. And there is some collisions. In countries we have criminal defamation, in other countries we don't have criminal defamation.
Defamation is a typical example of a content-related issue that has also connections with criminal thing. Are there other comments on this notion that the more interactions, yes, the more interactions we have, which is a good thing, the more issues there might be. Chris or Olaf, I mean. You could. Yeah, it works.
So, I mean, I agree that jurisdiction is a sort of gnarly issue that we've been dealing with. And before I came, in my earlier career, before I came to the State Department, I used to be a prosecutor dealing with cybercrime, and have dealt with a lot of these issues really for about 20 years now in different forms. What I'd say, though, is that jurisdiction, even though it poses some interesting problems, and we do need to see what we can do to promote better collaboration, and we'll talk about that later on, it's not going to, in my view, undo the internet. I mean, I think that the power of the cross-border nature of the internet, which, as you said, has somewhat given rise to some of these issues, still the benefits far outweigh some of the problems that we're seeing here. And so it is important to address these. It's important to do things to be able to address them. And I would say some of it is a conflict of norms between different laws, but a lot of it, quite frankly, is a lack of understanding in terms of how you make requests, how you deal with each other, how you can really expedite this. And we'll talk about that later on, but I wouldn't say that all of this is so unsolvable and so just based in the different legal systems or the different approaches to things that you need to wholesale change the internet. And the example for that is, and we've seen a lot of states recently because of this, and you made reference to this, think about things, countries think about data localization, to actually have all the data housed. And that may work on a 1 or 2 basis, and it's not even good on a 1 or 2 basis, but you can't scale that for 190-some countries. And it doesn't make any sense either for lots of different reasons, and it really leads to this fragmentation of the internet. So we can't lose sight of the actual overall goal of what the internet brings us while we're addressing this problem.
Olaf.
Thank you. I will try to speak about Hugo Grotius and Jürgen Habermas, and I start with Grotius. Because when we heard yesterday that Windsurf and the president were discussing, they had a notion that the sovereignty took over the international legislation. I would argue that that is not the case. Hugo Grotius both introduced the concept of Westphalian sovereignty, but he also introduced the concept of mare liberum. That is, he was the first to formulate a secular approach saying that there is a national sovereignty, but it's also in that sovereignty there is a duty, a responsibility to act according to international law. And that was that is exactly what we are doing when we tell the states that they have, within the framework of sovereignty, they have a responsibility to protect human rights within the territory. If that is the case, and if we do so, then we have dealt with an important part of the content problem. But there are still a procedural problem, and here I believe that Chris is. We can have sovereignty, but we can also agree on procedures. The sovereignty gives us space to deal with content based on cultural variations and religious things and all that stuff. The procedures gives us a consensus on how to deal with this in a way that is actually according to human rights legislation. And that is rule of law. And I was very encouraged to hear the Secretary of State yesterday speaking about that, because the American position and the Chinese position with regard to national sovereignty is quite alike, actually. The thing is that the Chinese is only interested to preserve the sovereignty to do bad things. The Americans' position is actually also sovereignty to act according to rule of law.
I think the introduction of the term rule of law in the document that has been adopted here in paragraph 4 of the operational part of the Tallinn Declaration is a very interesting element. Joanna, you wanted to say something, and I will come back to what Olaf was saying.
Just to add that I think there is also a development issue when we deal with jurisdictional conflict, because, for instance, for the US, it's easier to think that it's solvable and there won't be no problem. But if you are in Brazil, for instance, where all the companies are in the US, then the problem gets more complicated. And then we see initiatives that so far didn't happen, but on data localization and so on, but it might happen, I guess.
Can you elaborate just a little bit on, for those who haven't followed, in the Marco Civil that was just adopted last week, there was at one point an attempt at introducing the notion of data localization as a constraint in certain cases, and that has not been put in the end. Is it because, in your view, the Brazilian government saw what Nicola was saying, that it had unintended consequences or ripple effects, as was said in the panel that was there yesterday?
It didn't happen because they found another solution. The whole idea of having a provision on nationalization of data centers was actually to try to solve the problems with the MLATs, the multilateral agreements that doesn't work well. And then instead of doing that, they just changed the provision on data retention, and now it's mandatory to have data retention for 6 months for the big application providers, as Marco Civil says.
Okay. Dirk, you want to chime in on this question of sovereignty and application. And by the way, on content issues, Germany, like France, is, like Eduardo was mentioning for defamation, Germany and France, among other countries, have special rules regarding hate speech that do not match exactly the way it is handled in the US, if you can also touch on this.
Yeah, let me first say, as I understood it, in the Marco Civil, there is some application of the law going beyond Brazil, and that is interesting to see how that will work in practice. I think it's important to state we are not talking about a space which is devoid of law.
Certainly not.
Law does apply, international law does apply, but we just find difficulties in implementing it. I have to make this swipe now. As a Rhinelander, I have difficulties in applying the Westphalian Order, so I'm not so sure about the applicability of that system for the new space. But in any event, I think it's our feeling that when it comes to procedures, it's probably, given the transnational nature of this new phenomenon, bilateral procedures are probably difficult. We need something which is more transnational. companies, we heard that yesterday from the Google representatives, watch very carefully when they're being asked to hand over data. So they may deny requests from local or national authorities, and then you have that debate. When you want to ask another state, you may have yet another debate because you may think that politically speaking, it is perhaps not opportune to now ask for assistance because you see things quite differently. So all of this has certain negative parts. So I think a transnational solution is important. Whether that is, and I think we'll come to that later, whether that is a treaty, international treaty, where we would have doubts or something else is a different issue. You made that point about the content. Yes, it has always been a difficult, you know what I'm referring to now, it has been difficult for us when it came to propaganda material from the neo-Nazi scene, which we don't allow in Germany, but other countries where there is freedom of speech would have these groups who would then send it over to Germany. But that's differences which we have in law, and that's a fact of life.
But what is just to make a small comment, and I'll come to Andrew and Eduardo. One thing that is striking is that if you look at the terms of service of most of the platforms in the last few years, this issue of handling hate speech and potential bigotry, as some mention in their terms of service, has progressively been incorporated in the terms of service, although being based in the US, nothing was really compelling them to do that. So there's a sort of effort, isn't it, to somehow find a balance or to incorporate in the terms of service something that allows the platforms to respond to requests that come from a national government where the law is sufficiently protective, but has requirements that are not in the US. So we witnessed, honestly, a trend in the terms of service that try to find a sort of balance between what is acceptable in the various countries and what is required in the country of incorporation of the platform. Andrew, and I'll come to...
I think we may have to accept a certain degree of national differentiation about some of these norms. So if you take, there is a broad standard of free expression in Article 19, which most countries have signed up to, have signed the ICCPR and the Universal Declaration, that's fine. But within that broad standard, countries do have variations. So the US, for example, will tolerate Nazi speech because within their constitution, the answer to bad speech is more speech.
Yeah.
In France and Germany, Nazi speech is not tolerated because of historical factors. So the case, I remember the Yahoo case in France a few years ago, as you remember, Bertrand, where the French government sought to take down a site that was selling Nazi memorabilia. And I think the French concern was with the French citizens.
If I may say, not take down the site, but take down the content.
The content, yeah. And what Yahoo did, instead of adjusting that to France, it simply removed the site completely. So US citizens who are legally allowed to buy Nazi memorabilia, or Lebanese citizens who are allowed to buy it, were not able to. Now, regardless of the rights and wrongs of buying Nazi memorabilia, it's a sign that the danger is that companies that operate transnationally will respond to very specific national circumstances by simply saying, okay, let's go to the lowest common, let's remove anything that may be offensive to anyone. And once you start bringing notions of what's offensive into restrictions of content, you really start to lose a lot, because increasingly in our world, a lot of different groups are taking offense at the existence of other opinions and other groups and the expression of their views. So there is a genuine conundrum here that needs to be, that I think may require some national differentiation around some global norms.
Eduardo, and I'll make a comment on this one, because it's a nice segue, basically, on the second point I wanted to address.
I'm not sure if I'm going to jump too far, but it is, after hearing Andrew, I was thinking in my colleague's first presentation about Hugo Grotius and the international law. Yes, it's true. All the countries should respect international law, but as Andrew said, Article 19 has different, I would not say interpretation, but could have different implementation in different countries. So even if we accept that countries have to apply international law, we still have problems. And when I'm saying And the Marco Civil, as you said, maybe we need to see how it works in practice. And in practice means that, and that's why I say I don't know if I'm jumping too far in this panel, but at least what we will need is some sort of collaboration between countries. We will need some sort of agreement between countries, because it is impossible to fix and at least up to now to fix this problem, because we still have local understanding of international law, of local laws that sometimes are in collision with other countries. So without collaboration, without some sort of international agreements, I think that this problem is going to increase, not decrease.
Very short. I think what is important is to understand that there is a possibility to combine international law and national sovereignty. Yeah. And I think we can do it. And the way to do it, the way to mend the system is the procedures.
I see nodding, as people say in UN thing.
That is the procedures. Due process of law, etc., etc.
Thanks. Absolutely.
And I just wanted to echo that. I mean, you heard Secretary Kerry say this yesterday, that there is a difference between state sovereignty and interpretation of some of those universal documents, and the fact that they really are universal documents, and there are some ground truths here. So when states have criminalized criticizing their government, or engaging in, and really what I think we all would think is protected speech, that is going to be something we're not going to be able to assist on, and we shouldn't, because there are transnational universal human rights that are universal. We need to make sure that we're looking at that as well. So yes, there is some difference in interpretation, and then I agree with Olaf, it really goes back to the procedural ways that we can collaborate and cooperate. I'd say without a one ring to rule them all kind of agreement, but we'll talk about that later.
Yeah. Actually, I'll give the floor to Joanna, but I wanted to pick on what Andrew was saying, and just to make a comment, it is just because of the competition with other sessions that are in parallel. We have the major platforms who participate in the Internet and Jurisdiction Project, including Google, Facebook, Yahoo, and Microsoft and Twitter. But it turns out that the panel has mostly civil society actors and governments. But it's important to highlight at that point that the situation that Andrew is describing is an uncomfortable situation for the platforms, because they are caught between a rock and a hard place. They are exactly in this situation of having to make basically decisions on tensions between laws, which shouldn't be the responsibility of private operators, because the risk is either to overshoot or to undershoot. So I wanted to just make the statement in their absence in order to be absolutely fair. Joanna, you wanted to say something?
Just on the issue that of course I do agree that there are ways to combine laws and address the jurisdictional problem, but I just want to highlight something that I'm very worried about is when we talk about jurisdiction problem and cybercrime. Because I think then the tendency is to have more cooperation in this regard of human rights and user rights, and particularly if you take into account that these kinds of debates are not taking place in a very open manner. Last year, we had Seoul conference on cybercrime. We are going to have another one in the Netherlands. I hope they improve and make it more open, because last year I was like one or two only panelists from civil society, and texts were being debated in the backstage. So it's also a trouble if we get into agreement in that area in those terms. No?
In that regard, I want to pick on Olaf's remark regarding procedures. One of the things that has emerged, and maybe it's one of a nice segue on the question of collaboration. One of the threads that came out of the discussion in the Internet and Jurisdiction Project process, where we've been actually addressing this issue or facilitating the discussion during the last 2 years, is precisely the notion that developing what came to be called procedural interfaces between the different operators was a way to combine the different requirements of the governments, including law enforcement agencies, the platforms themselves or the operators of the DNS system and the civil society requirement in terms of transparency. In procedures, there are always two different dimensions. There are procedures regarding how you handle a request, like how you transmit a request for domain seizures or content takedown or access to user data. And the second element of procedure is how you enable a real due process capacity for the person that is concerned by the request to have contradictory procedures, the capacity to respond, and so on. Is there, when, for instance, Olof, when you're talking about this notion of procedure, are you talking more of the first one, like how the workflow is going in a certain way, or more about the substantive criteria, or both? I want to keep that one.
Yeah, that's a perfect introduction to Habermas. Because I talk about everything that creates legitimacy in the system.
Yeah.
And the legitimacy around the public sphere. And we're dealing here with the public sphere. There might be a perfectly legitimate concern in Germany to ban Nazi speech, because German history. But there is also a perfectly legitimate concern how the procedures works. So that is done according to a due process of law, and that you really safeguard the human rights when you are violating that legitimate concern that there is in Germany. So I think it's a question of both. And what is the big, I mean, those who know me know that I'm not a Marxist, but I think Habermas has a big point here, that the public sector should not only deliver welfare, it should also deliver security with regard to law enforcement agencies, legitimacy with regard to things like Nazi propaganda in Germany, and I think that is a fair thing to see to it. That, and what we have to address in the cyberspace is a legitimate order for dealing with these new kinds of problems. So the discussion that you introduce and what the work you do is extremely important, as I see it, to build on what we already do in the analog world and apply it in cyberspace in a way that makes people feel secure and free.
Thanks. That being said, the due process at the international level needs to be built, because there is due process in the different countries when it exists, but how it works at the international level is still to be developed. Nicola, you wanted to chime in.
Thanks. So getting back to this notion of intermediaries and process, I mean, I guess one of the big issues is that, again, as we said, obviously on the internet you can create a service in one place and deliver it in many other places. So now let's take the case of a country which, you know, through a due process and, you know, a jurisdictional court determines that there is some content on a social network that is defamatory or hate speech, and let's say that's all due process, all legal.
At the national level.
At the national level. Then I guess many countries found themselves facing a wall, because let's take the Turkey example. I think at the beginning the court wanted to remove specific tweets, but if I'm correct, they didn't get an answer directly from Twitter, for example. But there might be other cases where the government, through a legal process, wants to remove specific contents, and there is no sort of response, you know, from the other hand. So, you know, I'm not saying that, again, platforms should have a physical presence in every country. It's not possible. But how do we make sure that countries with specific, you know, legal frameworks are able to sort of enforce their legal determinations when these actors are not necessarily physically present? And the risk is that if they don't get a response, they will say, okay, so maybe we need to block the whole platform, or we need to do DNS filtering, which, you know, may have very bad consequences.
But that being said, to go back to what Andrew was saying, there is the question of proportionality, because I was talking about the procedural aspects of how to handle the request and transmit there, and how much documentation basically is produced in the request to explain what the case, what is the applicable law in the country, what's the procedure that has been followed. But still, that does not mean, as Andrew was saying, that something must be removed worldwide, and there are cases where the suspension of the content must be limited as much as possible in time, in geographic scope, and so on. Andrew, you want to say something, and Dirk has a point after.
I mean, I think one of the problems is that the global companies that have emerged to be the dominant social platforms are very new in the world. I mean, they're staffed with, you know, incredibly great engineers, but they're not used to dealing with these kind of very complex, nuanced social political problems. I mean, Twitter, I mean, I've spoken to people at Twitter, their biggest problem is Justin Bieber tweeting and the whole building vibrating because they, you know, the capacity of the network can go down at any time. And that's their preoccupation. It's not an offensive tweet being made in a jurisdiction, you know, 10,000 miles away, which they, it doesn't cross their, their corporate or operational horizon. So, and what they've said to me, I mean, I chaired a discussion between companies, governments, back at, I think, the Vilnius IGF. And the governments were saying, well, we don't want to get involved in this area, this is not something for national legislation. And companies were saying, actually, we need your help. You know, you're asking us to police a global regime of international speech which has been fought over for 50 years by a series of activists and lawyers and so on. We're not equipped to make these judgments and decisions. We need some help. And I guess that's where the idea of the Internet Jurisdiction Project comes in, to provide a baseline of guidelines and support so that if a company is faced with this, suddenly a problem arising, as happened in my country when some women had campaigned to get more women on the Bank of England banknotes, anonymized men started tweeting, I'm going to rape you, I'm going to come to your house and rape you in front of your children. Really, really quite extraordinary tweets directed to these women. And it took Twitter about 3 weeks to respond and take down those individual tweets because they clearly had crossed the boundary between, you know, a comment that you might find offensive and something that's very actually threatening to someone's security. But I think it's just, they just weren't equipped to manage these kind of problems that can occur in any jurisdiction at any time, in any place, when their business model is about providing a platform for people to communicate. It's not a business model that's designed to police how people talk to each other.
And if it's already a problem for companies that have the visibility of the companies you mentioned, imagine what it is for a small
any smaller company will simply take the safety first option and say, if I've got a problem, I'm not going to take the risk, I'll just take it down. Everyone, any private sector organisation will go, I think, safety first rather than say, I'm going to, you know, really go on the free speech line. Yeah. Unless they're big ones.
As a matter of fact, it hasn't been really, just to make a comment, it hasn't really been the way it worked at the beginning. And this is why this problem emerged in a strong way, because the first approach was more, because we're located in the US, it's the US law that applies, and therefore we take down nothing. And then it got into a spiral that Nicola was mentioning, like if that is the case, I block the whole platform, then you have to respond. But I get a lot of, Dirk was next, and Eduardo.
It's dangerous up here. I'm standing next to a cliff here. Quite interested, on the edge, yeah, quite interested in seeing all these comments on Habermas. When I was in Palo Alto for the EAAI summit, where Chris also participated, there's a big American internet security company, and the boss of it had written his thesis with Professor Habermas. So there must be something about cyber and Habermas. I'm not quite sure what, but due process was mentioned several times, in particular by Olaf. Just this morning read a story that Microsoft had lost a court case at a federal court in the US about data which are somewhere else, and the judge decided that the company would have given data to authorities wherever the data are. Microsoft said they will challenge that. So here there is an issue where you may have due process, but this can be difficult for the company, number one. Number B, it may be in conflict, also it is due process, it may be in conflict with the law of another country. Yes. So there's due process, but there's also the issue of when a law is applicable and when that law may be in conflict with the law of somebody else. back home, we were thinking in terms of process, we were thinking about various alternatives, and I will only mention one of those options we were looking at, which is voluntary standards, which could be agreed upon by main actors here in this field, like companies, states, administrators, etc. So you could try to work with some of those, see whether they are efficient, whether you can ensure human rights by using those. And how did we come to look at that option? Because, you know, also global economic relations sometimes have this problem that how do you deal with transnational issues, and how can you do that when national laws can't give you the way out of it? So in economic relations, we do have what we call international courts of arbitration. It's one instrument. And then, and this one I have to read because I can't learn it by heart, but what my colleagues in the law department told me was that there may also be taken some good input from the International Registry of Mobile Assets based on the aircraft protocol to the Cape Town Convention. So why did they mention this one? Because it provides transparent access and legal standards in the field of international interest in mobile equipment. That's why they were looking at that one. I'm just mentioning it without knowing really what is in there. But that's what my lawyers tell me might be an interesting avenue.
Well, the notion of having a form of agreement among the different stakeholders is clearly one of the ways forward. Knowing that there needs to be some innovation in the frameworks themselves. I will ask the different comments and then ask if there are comments from the room as well.
So I think those kind of voluntary arrangements can be very useful. I also think you have to be careful of the slippery slope argument. I mean, the more, and you made this point, the more you start taking down speech that's out there, the more you lead to really an undermining of the platform where people really can express themselves. And there's certainly very repressive regimes which have a totally different idea of what speech is allowed. And I remember having a conversation, I won't name the country, once with a country, representative of a country, where I was talking about the importance of a public-private partnership. And they said, well, absolutely. We could not possibly monitor everything on the websites for content we don't like. We need industry to do it for us, which is a different concept of public-private partnership than we do. So I think, you know, there are two things here. One, it seems almost, I can't imagine a time when it's appropriate to take down a whole platform. And I think we have to avoid that. And these voluntary arrangements and better legal arrangements are important. And we, years ago, within the first G8 context and then much broader, and there are about 60 countries that are a member of this now, have this 24/7 network to facilitate these kinds of interactions between law enforcement authorities. But I will tell you that one of the biggest problems, and it maintains to this day, and this is why we also need some capacity building in this area, is that requests that countries send, so it's not just a company issue, it's also a country issue, often just say, give us everything you have on this IP address, which no one can both protect human rights and the rule of law and comply with that kind of request. So there's a lot to be done in terms of formatting, in terms of what kinds of things you're asking for, in terms of really making that much clearer. And then just in the United States, I say that one of the big solutions, that one of the problems, again, government to government, has been these mutual legal assistance requests, which can take years because they were written long before the internet. And you know, often in the U.S., they've gone up something like 60% in the last 7 years. So that's a huge increase. And it's both because there's more crime on the internet, but also because there's more stuff on the internet and there's more evidence there. So President Obama recently announced a plan to really try to strengthen and modernize that system, devoted $24 million to our Department of Justice to expand its ability. And streamline it. Now, it still will not be overnight. It won't be network speed, but it needs to be much quicker, and that avoids some of these greater problems. And so the more we can do in those kind of voluntary measures, strengthening what we have, streamlining processes, the more we can then just concentrate on the harder problems and not have to deal with this whole group of problems, which I think is driving a lot of the debate in countries where they're thinking about, well, how can we get this data because they need it?
Well, what is interesting is that both in the exercise that we're running and the MLAT reform, and also what UNODC in Vienna is trying to do, the notion of the format for requests is becoming a big common thread. And to go what Andrew was mentioning, the notion of having the lowest impact possible in terms of temporal and geographic imprint regarding anything that is related to content is emerging as a sort of norm. Just to make a comment, even in the Twitter case in Turkey recently, the court has basically sent a message that taking down a whole platform because of one piece of content is not proportionate. So it's a real emerging now. Eduardo, quickly, and then if there is a comment from
very
the
briefly.
room.
I think that here when we were talking about due process, maybe we are talking more about enforcement than due process. Because, I mean, we can accept or we can understand that one country has a perfect due process in a particular case, but other country doesn't accept that process. I mean, for example, in the United States, we have that concept about the First Amendment due process. And this is something that in the UK, maybe they are not accepting, and vice versa. So at the end, the question is enforcement. If we are going to enforce one decision in one country, taken in one country with perfect due process for that country in another jurisdiction. And the other problem, this is one theoretical problem, but the other problem is more practical and is for the companies, as Andrew said. And I am a little bit concerned because when we are discussing this problem of the applicable law and jurisdiction, and we start thinking that the companies should take their own decisions, we are putting in the hands, in the shoulders of the company, decisions that should be on, not on the companies. And the problem is that maybe big companies can do a good assessment of the process, but small companies are going to do exactly what you say, Bernard. They are going to shut down everything because they don't want to have legal problems in a particular country. So leaving the companies to solve this problem alone, I don't think that this is the way to solve the
key
the
challenge
problem.
is that it cannot be the law of the country that sends the request that applies worldwide, and it cannot be either the law of the country of incorporation of the platform that applies worldwide. And so in between, dispute resolution mechanism, as Dirk was mentioning, is probably one thing that has to be taken into account. I suppose that there's a mic rowing in this room. Is there any comment or question? Yes, sir. Over there. Is there an additional mic? No? It's a competition for the mic. Never mind. Any other comment? Go ahead.
Peeter Matsküla from Estonia. You have been discussing the hate speech and what is considered hate speech quite extensively. There's another area where many countries have already reached sort of consensus, which is intellectual property and in particular copyright, where 167 countries are subscribing to the Berne Convention. So despite there is seemingly a consensus between countries, the world is still very much fragmented into territorial areas where different licenses must be issued, etc. And I would also like to hear the panel's opinions on how to fix the territoriality of the copyright versus globality of the internet. And on a side note about the proportionality of taking down an entire platform in response to an alleged violation of certain laws of some countries, the cases of the global witch hunt against Mega and the Pirate Bay, for example, and BitTorrent as a tool, not as a particular violation.
Any other question? Sorry, any other question in the room? Not so far? Okay. Who wants to address the question of copyright and the different tensions regarding rights that are territorial? And Olaf?
Yeah, from my point of view, I think it's important to give enough time for the market to find solutions. I think that we have been rather successful actually in finding market solutions on many of these IPR problems. and there is a different discussion today compared to how it was 5 years ago, for example. And I think that is, we will always be behind the curve with regard to the development of the technology, but we need, those who will be most behind the curve will be the legislators. The market will always be ahead of the legislators, and I think that is the case here as well. So I think that what we have seen the last years is actually a rather successful adaptation of the issue, the concept of property rights and the globalization of the internet.
Nicolas?
Thanks. So to the question, how do we reconcile the transborder nature of the internet and the national nature of copyright? Well, maybe the response is a reform of copyright, but let's not go too far there. But there was an interesting example on that actually in 2011, which was the Roja Directa case, where it was a website streaming videos in Spain, and for the Spanish government, the website was doing legal activities, but the US decided that it was not the case. So actually they took down the .org and .com domain names, yeah, I think that's an interesting case of the extraterritorial jurisdictional issues, and that decision was reversed, I think, the year after. But that's an interesting case.
Eduardo, you want to say something?
Yeah, I think that you touch the other, I would say, hot issue on jurisdiction. One is speech and defamation and hate speech and the problems that create for jurisdiction in the cyberspace. And for me, the other is copyright. But with copyright, we have to add another problem, that we have some sort of internationalization of the problem because of the Berne Convention. So we have an international convention there, we have some sort of international agreement there, and how to, combine this Berne Convention with the cyberspace is really complicated. Maybe what we can do around this problem, internet and jurisdiction problem, is first start to, detect where are the niche, where are exactly the cases that create problems. Defamation and speech and hate speech is one example. Copyright is another example. And then try to fix, the problems and try to get agreements in this kind, on these particular issues, and not to try to fix the problem as a whole. It's just a suggestion.
Just one comment before I give the floor to Andrew. You raise a very valid point regarding the scope of the Internet and Jurisdiction project. Of course, on jurisdiction, there are also many other issues. There's taxation, and there are many other aspects. What is important, and I think Eduardo is already touching on it, is that in the case of copyright, it's mostly a matter of how to implement something that is more or less agreed. And it turns out that at least on major platforms, some of the technical tools have been put in place to facilitate, whether we like it or not, the actual implementation. On the issues regarding defamation or hate speech or other types of content that are objectionable in one country and not in another, it's a conflict of norms, which is a different type of problem because there is no overarching issue. To be frank, this is one of the reasons why we have not dealt with so much in the project with the copyright aspect or the taxation or others, and focused on situations where there are potential conflicts of norms and there is no overarching element. Andrew, you wanted, and then Joanna.
Yeah, it's a more general point about, I think, the process and the way we discuss these things. Bertrand, one of the things that constantly amazes me about every internet forum I go to is there's very strong representation from governments, very strong representation from business, lots of civil society people, but there are never legislators. Or
That's
hardly
true.
ever do you see the legislative arm present in the discussion. And if I'm dealing with a complex problem in my own country, and Britain's a complex country with many different agencies that I have to deal with, in the end, if I can't figure it out, my elected representative is the person I go to actually represent me. And they are the people who are often react very foolishly. When we had riots in London, there was a call to bring a law in to take down BlackBerry, for example, or pass legislation that would allow that to happen in the event of a similar riot. And I just think our legislators are the constituency of the democratic picture that are never part of these discussions. And I think we all need to think more about that. And I would suggest your project could think about how to incorporate legislators as part of that discussion, because they need to be aware of these debates about voluntary norms and interrelationship between national and international jurisdictions. And in my experience, if I go from this kind of discussion into the British Parliament, it's like walking into a void in terms of what these issues are about. And yet they can pass laws almost at any time that could have a catastrophic effect on the integrity of the system. So it's an appeal to all of us, really, to think more about bringing the legislators into this process and not just leave it to the officials, civil society and businesses.
I'm not sure it's specific to Britain. Joanna?
Just to add on the issue of copyright, even though we have the protection set in Berna Convention, the exceptions and limitations are not that uniform. So there is a tension that in the case of Brazil, we don't have fair use, for instance. And what happens there is that just ISPs and the copyright industry makes an agreement to remove everything. And it's just business with business, sometimes dealing with issues on freedom of expression, because, for instance, you put a soundtrack in a video of a protest, and then they take out that protest because there was disagreement for notice and take down. So it's still an issue, even though a bit easier than the others, maybe.
One of the things that is interesting, Olaf. Yes.
Yeah, just say App Store, Netflix, Spotify,
Hulu,
and e-books. There are a number of market solutions today to this issue. So I'm not that worried about that kind of problem, actually. I use all these services, and I feel very comfortable with being able to pay for what I'm doing, but also a reasonable price because of the fact that there's such advantage of scale, thanks to the internet.
If you want to chime in.
Just as you mentioned, Netflixes and ebook platforms, music platforms, app stores, etc. Due to the territorial nature of copyright, many countries, including many EU countries, including Estonia, have very recently been locked out of that network because the publishers have given the sales platforms the licenses for particular geographic markets only. Netflix is still not available in Estonia. Spotify became available in Estonia only recently. And the content, the authors want to have their content everywhere. The authors want people to be able to enjoy their content, to enjoy their creations. People in various countries would be very much willing to obtain this content legally, but they haven't been given a way to do it legally. So this is a very existing, very real problem. And the fragmentation has already occurred.
It's a clear dimension of fragmentation. One of the things that I wanted to pick maybe for just one minute is, we were talking about, and it is indirectly related to this question, because one of the technical solutions is called geo-IP filtering. So depending on the IP address, content is accessible worldwide, but not in a very particular zone because it is illegal in that country. That applies for copyright, but that applies also for things that we discussed, like defamation or hate speech, etc. One of the challenges is the following. It looks like an appropriate technical solution. Helps for proportionality, helps to have the granular decision. If it is generalized, and if it leads to a certain number of countries requiring that the distribution of IP addresses is being done, sorry for being a bit technical, but is being done on a national basis, which is not the case today. If this further becomes embedded in every mobile device as an identifier, does it have a ripple effect, a danger in terms of traceability and so on? Eduardo.
Well, two things. I think that in practical world, this kind of solution maybe is not going to work because today, for example, we can bypass the IP using a VPN or something
But
like
you know
that.
there are some countries who are now
Not allowing,
making
yeah, okay.
illegal the VPN.
But I
because
would
of
say that technology can, move forward and not, to allow that as a solution. And the other problem is that even if that is the case, that internationally we agree on that, there is, for me, a bigger problem that you are going to isolate communities to be connected in cases where they more need to be connected. Let's say, again, the defamation speech. Somebody call a content a defamatory content, and you cannot listen to, a criticism against your government in your country that has been made abroad because of this, VPN or this IP, solution. So if we move forward to that way, okay, yes, the criticism could be, or the critics could be heard or could be read or could be anything all around the world, but not exactly in the place that it is more necessary. So I think that we are going to create another problem with that, or we could create another problem with that kind of solutions.
I would say we're nearing the end of this discussion. So, of course, there's no way we can, in a 1 hour time session, fix the whole problem. What we try to do is to basically highlight a bit of the landscape, the complexity, and to summarize the thread is to first recognize that this is not a problem that is a flaw of the internet or cyberspace. It is a consequence of its success, and it should not be something that basically triggers reactions that harm the very success that the internet is. And that second, that it is a problem that is shared by the different actors. Although they were not here, everybody mentioned also that it is a problem for the platforms themselves as well as for the technical community, the civil society, and the governments. And that third, around the notion of due process, developing procedures and some form of voluntary standards is probably the way to go, which is what we're trying to do. Is there, please, if you have one message or one thing that you want to share, or even make a connection to processes that you are involved in as a concluding remarks. Maybe we start with Andrew in that direction to do the other sense.
Yeah, I don't think there are technical solutions to essentially political and due process problems. And I think that's why the IJ project is an important part of trying to find the voluntary solutions to these problems, which requires active political collaboration and cooperation.
Well, Andrew stole my conclusion. Yeah, let's fix the jurisdictional issues, because otherwise we might see technical solutions or measures that might be even worse for the internet.
You mean actually trying to solve at the infrastructure and protocol level something that should be handled at the legal...
Exactly, not using technical means to solve legal or political issues.
Joanna.
Just to add that after Bertrand Visionnaire addressing this issue, this is already in for the revision of the Council of Europe of its strategy as an issue to tackle, and it was also included in Net Mundial as a priority issue to be further addressed. So we must be hearing a lot about internet and jurisdiction for the next years.
Yeah, we were actually very happy to see that it was even mentioned in the
and having been in Brazil and coming directly from there to here, yes, that was one of the many topics in the roadmap going forward. And I'd say, this is a balancing thing where you have to be very careful, because when you talked about some techniques that you mentioned, Bertrand, the problem is those could be used by more repressive governments to filter content that really is something that be guaranteed under free speech rights. So you have legitimate law enforcement interests, and but you want to keep the internet open. And so that's why I think it's important to both look at voluntary arrangements, but also really strengthen the way we deal with procedures. So that's why I mentioned our MLAT modernization. Those kinds of things I think can help address these problems with making sure that it's in accord with the rule of law.
Yeah, I think that when in 2012 we got the first international acknowledgement of human rights offline online, and that was the theme of very much what was said in Sao Paulo. Now we are introducing the concept of rule of law online, and that is slightly more difficult because rule of law is not that as well defined as human rights in international organization. But I think we are making progress. I'm a fan of Maria Montessori's way of learning. Start with the whole and go down gradually down to the pieces. And we are doing that in the right way now, I think. So I feel quite comfortable, actually.
Yeah, in this kind of discussion under your very important project, we usually reach to the same conclusion that we need voluntary agreements, we need collaborations between countries. But my question always is, well, should we be optimistic about that or should we be pessimistic about it? Do the countries are going to get agreements, yes or no? I tend to be optimistic. When many years ago, 70 years ago, people start talking about the possibility to have an international criminal court, nothing to do with this issue, but it was a very important issue around the world. Many people say, international criminal court? That will never happen. We have now an international criminal court because of the agreement of the country. So we have room to be optimistic that could have, voluntary agreements, collaborations between countries, and international agreements as well.
Dirk, the final word.
Yeah, as the last one, I'm probably left with the level of pieces, and I will add just one piece. Some companies in Germany told me that they are very much concerned with another issue, which would be, I don't know how you call that in English, responsibility, liability, probably liability. Data moves so fast, and who's responsible or liable for the data at what point in time. And they feel very insecure about that. So that's probably something to be tackled as well. That's all. Thank you.
Thank you very much for the comments and the contribution. It's time now to close. We are about on time. You can pick on the tables two documents. One which is basically the description of the current status of the Internet and Jurisdiction Project, development of a framework to handle transborder requests. And you will see in the document the 6 building blocks that represent the skeleton that we're working on, including request formats and issues of determination. You will see also a document which we have released during the Net Mundial last week. Please feel free to connect with us. There is a newsletter that every month is called Retrospect on the internetjurisdictions.net site. And every month it collects 20 cases related to jurisdictional issues that are collected and crowdsourced and crowd-ranked by an observatory of 30 academic experts from more than 20 countries in the world. So don't hesitate to register for the newsletter. Get in contact with us. Paul Fellinger is working with me on this project. You can subscribe to the Twitter feed as well. And we will update people regularly, not in particular at the Internet Governance Forum in Istanbul, on the progress of this discussion and the development of the framework. Thank you so much for having been here and to have managed to get the time almost okay.